Good afternoon, everybody. I almost said good morning. We're going to wait a few seconds so everybody can roll in. I do ask that if you are in here and have a first or just a last name or an abbreviation, please rename yourself to first and last name. It's incredibly helpful when we are reporting CEU credits. Especially I like to pick on the Mikes of the world because there's usually about 6 of them in every session. So if you can just look and see how you appear in the participant list and rename yourself, it would be incredibly helpful. We'll give it another second or two. I know we had a good bit of people registered for this session, so I want to give them all time to get in here.
Are we going to get a list of who is in the session?
Maybe, possibly. Yes, I can talk with you offline about that.
Okay, because there may be materials that are relevant to what we're speaking about today that I could forward out to everybody.
Okay. All right, so with that, I think we're at 40. We were expecting about 61, so it seems to be kind of ticking up a little bit slower. So with that, I guess we'll get started. So again, if you just popped in, I ask that everyone please make sure that you have first and last name in the participant list so that we can correctly report your continuing education credits for you. This is the voice of Kira Kellner at AIA Pittsburgh. I will be going into the background here, but I would like to start off by introducing Nicole Rice with Langen. Langen is a session sponsor for Build Pittsburgh this year and is sponsoring this session. So with that, I will turn it over to Nicole.
Hi, everyone. My name is Nicole Rice, and I'm a senior project manager in the environmental group at Langen. For those of you who don't know Langen, we're a multidiscipline engineering firm with site civil, geotechnical, environmental and traffic engineering, as well as survey and landscape architecture. So pretty much everything from the ground down. For over 50 years now, we have been supporting land development projects, corporate real estate portfolios, and the energy industry. We're excited to be working on several major development projects in the region, and we have over 32 office locations across the US, including 2 new locations that we're excited about in Chicago and Austin. We're the proud sponsors of this session on the importance of understanding construction risks. And I just wanted to thank everyone again, and I'll turn it over to Mike now.
Okay, good afternoon, everybody. Welcome to Build Pittsburgh 2021, which happens to be the second annual virtual Build Pittsburgh and hopefully the last as far as I'm concerned. I'm going to share my screen with the PowerPoint. Let's see. I guess I need to scroll through. All right. Title of this is Design Excellence Requires Understanding of Construction Phase Risks. By way of introduction, first, I'm Mike Cremenes of Burke Cromer Cremenes. Many of you know me. I am a routine speaker at Build Pittsburgh, along with Paula Salvaggio of the Oswald Companies. And this year, Paula and I have joining us Ann Chen from GBBN Architects and Nicole Mangino from AXA XL Insurance, who will be joining us a little bit late. She's not on the call yet. And then a list of the sponsors, which I think we've already seen at the beginning of this. And so let's start with what are the learning objectives for this presentation? And the first thing is identifying the risks to the architect that could arise from the construction phase. To understand how contracts are used to modify those risks, to understand how to mitigate construction phase risks through contract language, project performance, and communications, And most importantly, the understanding of the importance of understanding the construction phase and construction phase risks when planning and designing a project. The presentation is going to focus probably mostly on point number 4, the importance of understanding the construction phase when designing. So let's start with the purpose of your profession, the purpose of architecture. I think this is a good starting point, is the Pennsylvania licensure law, and most states have similar provisions in their licensure law. And the declaration of purpose for the licensure law is in order to protect the health, safety, and property of the people of the Commonwealth of Pennsylvania and to promote their welfare, no person shall engage in the practice of architecture in this Commonwealth except in compliance with the requirements of this act. So it's a pretty hefty duty, and it's why architects have a license, so that somebody on a construction project is out there protecting the health, safety, and welfare of the people and promoting the welfare of the people. Practice of architecture is defined in the licensure law as the rendering or offering to render certain services in connection with design and construction of a structure or group of structures which have as their principal purpose human habitation or use, and the utilization of space within the surrounding structures. The services referred to, architectural services that is, include planning, providing preliminary studies, designs, drawings, specifications, and other design documents, and construction management and administration of construction contracts. Those are all architectural services which represent the practice of architecture and require a license. So the first thing to ask is, what is construction administration? A lot of people use this term erroneously. It's administration of the contracts for construction or the architect's services. Construction administration is a term that is thrown into contracts and for which you should be wary of, because it may mean something other than administering the contracts. It may mean something other than construction management. As we know, a lot of construction management services today are performed by construction managers, not architects. And so it suggests a heightened responsibility for project means, methods, techniques, sequences, procedures, and for safety precautions that's not ordinarily part of your responsibility during the construction project, but it is always something that you should be looking at with an eye towards for the protection of the health, safety, and welfare of people. What is design excellence? And I would say, looking at the statute, first step to design excellence is protecting the health, safety, and welfare of people, of promoting the welfare of people, accomplishing the owner's objective, which may mean meeting the client's expectations, owner's expectations, designing a project within the owner client's budget, meeting the owner's client's schedule. But most of all, design excellence, it requires harmonizing the interest of people with the client's objectives. Think of this in terms of one of the provisions of the B-101 contract, which is the architect shall consider sustainable design alternatives, such as material choices and building orientation, together with other considerations based on program and aesthetics, in developing a design that is consistent with the owner's program schedule and budget for the cost of the work. And this is really one of the avenues where your professional expertise comes into play, is achieving that design excellence within the owner's program. So at this point, I'm going to turn it over to Anne to give us the expertise of an architect on this.
I love the contrast between the legalese version of design excellence, and I think how we as practitioners and really those who recognize, and certainly the AIA framework for design excellence recognizes that the architect's responsibility goes well beyond, the client and well beyond current times, looking towards, the fact that what we design, if it gets constructed, it is there for decades. And frankly, there are buildings that have been around for longer than a century. And so design excellence is far better than design good. We are looking towards really building the environment that we want for not only ourselves, but for our children and for future generations. And I think that the AIA's framework for design excellence is fantastic. It's a fantastic resource. And so if you're here, you know that, and you are committed to that. The next slide. So, design excellence, it can't be experienced unless the construction process is successful. The design excellence that we convey onto a piece of paper is only as good as what can be built. And so we all know, and again, if you're here, you know that the construction process is essential to providing those experiences that really engage the public and provide the spaces for us to all share and learn from each other and engage in discussion. So, as we really are trying to achieve upon these ambitious goals, aspirational goals of designing spaces towards equity, inclusion, sustainability, the spaces that really convey values that are important to us as a community, we need to set up the construction contract administration process to succeed. And, we all have a joke as architects about archi-speak when we talk. But I find that it always bears reminding myself as well as the people I work with, that our construction contract documents, our drawings, and our specifications need to be understandable and clear to those contractors. They are for the contractors. They are for the contractors to understand and be able to build something that achieves on the design intent. When we are designing something, then these are just a couple of, I wanted to put in three, kind of primary sort of guidelines that I think are really important in developing and leading up to the construction process. But if we have a system that is complex, whether it is an exterior wall assembly, a rain screen assembly, or a really important interior assembly that has some complexity to it, allocating clear responsibilities is tremendously important. So, whether it's defining that entire assembly system needs to be owned by one contractor within the specifications, and that there are certainly designated places where there's a handshake, there's a system that's touching another system that needs to be clearly defined that there are coordination issues for that, but that responsibilities on trades are really clearly articulated. And then third, and I think in some ways this is one of the most important going into the construction process, that there's a collaborative team dynamic and relationship. The contractors, this is very much a part of avoiding problems and minimizing risk. If there is a collaborative approach to the construction, that the contractors have expertise that we are very respectful for, and that we need to really make clear what is important through the construction process. What are the elements of the design that, really there are no compromises. So at the start of construction, holding a meeting to articulate these sort of no compromise elements, explaining what they are and why, That engages the contractors in understanding their collaborative role in this. And then that you're willing, you need to be willing to compromise in other areas. And I think we all have stories of areas where we have compromised and it's bought us the things that are really important. And anticipating the issues before they become crises, that's tremendously important. This is all about avoiding the risks, and there are really large risks, which Mike and Paula and Nicole will articulate.
So moving on, Paula, do you have any thoughts on some of the things you have seen that you would consider foster that design excellence in the real world environment of a risky construction project?
I would say that number one that comes to mind is the folks that are not able to do, going out to the site observation. And notice I said observation, not inspection, because there's no other way for you to ensure your design intent is being met. And you're the designer and you don't go out there, somebody else is interpreting it. And we see a lot of claims come from those types of projects where our firm said, well, I wasn't hired to do that. Well, you're still going to get named in a lawsuit because you should have done it. It's part of your duty as an architect to make sure that your design intent in general is being followed. So if you don't do it, then you need to contractually do something to protect yourself. And I would say an indemnity, including defense, that the owner is going to pay for if the project gets built in a different direction. That's the number one.
Yeah, so following up on Paula's comments there, and I think she hits on a good point, which is not often done in practice today, that the actual designer of the project is the person that's making those periodic visits that we'll get into later, the periodic site visits. So the issue there is if you're going to have somebody that did not put the design together, doing the periodic site visits that are required by your contract, that person has to have a very workable knowledge of the design and the design intent, and should be involved at the time that you're designing it so that they have an understanding of what's being designed, why it's being designed, so that they could go out in the field and make sure that in general that the design is being achieved. So as Ann was mentioning, the construction project is a team effort. And it's an interesting team effort to me as a lawyer, in that the architect's design is near complete when the construction starts. And in the traditional design bid build construction project, that means the design is usually completed before the contractor even gets the project. Now, there are variations to that where the contractor's involved up front and then there's design build, and I understand that. But you have a situation where as part of that team, you're performing services and designing the project before the person that's going to build that design is instrumentally involved. But probably over 70%, maybe over 80% of the owner's costs are going to be in the construction phase when they have a constructor interpreting what is designed to apply their skill and expertise to construct what was designed. And therefore, I say design excellence, and I think this presentation, design excellence requires that during the design process, the architect understand the issues that a contractor, a constructor may have in interpreting the design and implementing and constructing the design that's laid out. And Ann and Paula, if at any time you want to chime in with thoughts on that, go ahead.
Yeah, I mean, I do want to reiterate the comment you made, which was a really good one, Mike, that if it's not the designer who is doing the construction contract administration, it is someone who is is very knowledgeable about the design intent, because we all know design doesn't end when the construction documents are released. There are always decisions, and there are always issues on site. And that person who is representing the architect, of course, needs to really understand the design.
And I would add that I'm a big proponent of the collaborative processes that are starting to be implemented around the country. IPD specifically, anybody that's on the call that's a member of Cogents, that I'm a founding member of in Ohio. It's promoted so much teamwork, having the contractor involved in the design right from the beginning. It takes away a lot of stress. You have to have the right owner though, because sometimes owners want things for nothing. And so you have to be able to do that, and you have to have good legal documents, because there's a fine line between design and construction. There's a fine line between insurance coverage when that happens. So total different presentation, but I'm a big proponent of the collaborative process. Whether you do IPD or not, I think it's happening more and more around the country.
So one thing I'll note about the construction phase services, the best, probably if you're using the standard AIA documents, the best place to go look for what happens, the legal side of the construction phase is the A201 general conditions of the contract for construction, which has all of the contractor's responsibilities, will have the architect's responsibilities, the owner's responsibilities, and if there's a construction manager, the CM version will have the construction manager's responsibilities. And those are all integrated, and the architect should understand all of those roles and responsibilities in trying to achieve that design excellence that they're looking for. But starting with the A201, paragraph 1.2.1, the intent of the contract documents is to include all items necessary for the proper execution and completion of the work by the contractor. So starting with that in mind, your design should be attempting to include through the contract documents, which are the drawings and specifications, which are complementary. What's required in those is, if it's required by one, it's required by both. Understanding that that's supposed to give the contractor a complete picture of what they need to build. And performance by the contractor shall only be required to the extent consistent with the contract documents or reasonably inferable. You're not going to achieve every element that the contractor needs to perform to in the drawings and specifications, but reasonable inferences will need to be made, but they have to be reasonable inferences that you will expect. And then, as Paula mentioned and Ann mentioned, the collaboration of the parties is important to design excellence. So in that regard, unless it's a public bid job that has to be design, bid, build, as an architect, when discussing a project with your client, you should encourage early participation of the constructors who can be involved during the design process to advise regarding constructability of the project, but also the other important items for the owner, the budget and schedule. Is the owner going to be able to achieve the project that's constructible within their budget and can be done within their project schedule? And will this all protect the health, safety, and welfare of the public, of society, and promote the welfare of the people in Pennsylvania, of the Commonwealth of Pennsylvania? The architect should invite comment and critique. There's no reason to get defensive if somebody's asking a question about why you designed something a certain way. Try to encourage, even if you don't understand or you don't think that it's a constructive criticism, try to understand where it's coming from, because that is, that will be coming from, especially if it's coming from a constructor, from the person that's implementing your design, that's building your design. And so therefore you need to understand what their concerns are, what their comments and critique are, so that you can, again, achieve the design excellence. And the goal through this collaborative process is to reduce changes, therefore reducing claims, and therefore you should answer questions regarding RFIs, or questions, which are requests for information, early in the process, as early in the process as you can. Ann or Paula, any follow-up on that?
Nope.
All right. As an architect, and I'd like to say we as lawyers are problem solvers. We're in the problem solving industry. And that problem solving for architects is part of the design process, but it also goes forward into the construction process. So maybe, Ann, you could describe how you go about the problem solving for a client when they come to you with a project.
Oh,
Putting
well,
you on the spot.
yeah. I mean, much of it comes with, asking the right questions, really understanding their vision, and oftentimes that's about getting beyond, maybe the quantitative goals of their project, getting to some of the qualitative issues, whether it's really, providing a really healthy workplace for employees that they want to go to, that they will feel really creative within, or whatever that might be. Understanding, of course, the budget and schedule implications, designing something that we all have had the experience of designing something that isn't to budget, that is always frustrating for everyone. And so understanding budget and schedule implications are an important part of meeting the goals.
So I have a question for you, Ann. How do you handle the client that wants their project done in a time frame cannot
Can't be done. We have all been there.
the cost?
Right?
That those are hard discussions. So how do you handle that? Go blindly and hope it works out? And remember, you're my customer, so
Yeah.
how the answer is going to affect your premium.
It often involves getting contractors involved, whether it means bringing to the table those other entities that will be involved in implementing. And we have often had the experience where clients won't believe us, but they'll believe a contractor. So, or they'll believe, they'll believe a real estate broker. So bringing together, other people who have expertise in order to validate what you're saying is important. And putting together timelines really helps. I mean, I think most clients realize that, and they will hear it from other clients, that the permitting process is a long process. So when you lay that out and you have other people validate that, that's part of it.
Good.
Excellent points. Go ahead, Paula.
No, I was going to say it was a good answer, because you're right. I think if the owner hears it validated with more than one person telling them, it just, brings some to the client. Now they're sitting there going, okay, well, maybe I'm wrong. So I think that's a good way to approach it.
So just following up too on something Ann said about solving problems, asking the right questions. I think it's equally important to listen carefully to the answers, because ultimately in solving the problem, you have to address the client's concerns, which are, or the contractor's concerns, which are expressed in the answers to the questions that you ask. So standard questions from a constructor on a project will be in the form of an RFI, and the contract requires that you shall review and respond to requests for information about the contract documents, and that your response to such requests shall be made in writing, and if appropriate, you should prepare and issue supplemental drawings and specifications in response to the RFIs. So everybody knows the RFI process can be apparently abused at times by certain people on a project to set up error or omission claims. Put that aside. When an RFI comes in, assume that it's a legitimate question and provide the answer in writing. The contract requires you to respond in writing. Reference the contract documents, the drawing number, the detail number, the specifications, where it is in the design, they can find the answer to the question. And the more you do that up front, if you do that up front early on in responding to RFIs, number one, it leads to the design you're trying to accomplish, the design excellence. But number two, it also makes the constructors realize that they're probably not going to be able to establish a claim through the RFI process if every time you come back promptly with the response to the drawings and specifications. How do you reduce RFIs though when you're designing a project? Put yourself in the constructor's shoes. Where is it that the constructor may have a question about your design? And I understand that a lot of times you're trying to get design out to meet a deadline, just like a lawyer is trying to get a brief out to meet a court deadline. But the best practice is have it done a few days before and go back and look at it the day before it's due or 2 days before it's due and make sure you would have made all those decisions. For architects, it's probably a week before, so have it done a week or two before. So you go back the next week and look at it with a clean set of eyes. And maybe it's longer than that. I'm not, I just know I hear so many stories, we're rushing to get something out the door. So maybe Ann could chime in on that.
That's such great advice. It's so hard to do. That's all I'll say. It is great advice. It's really hard to do, but yeah.
It is hard to do in time crunches we have today, but if you can put it on your calendar to get it done in advance so that you could have a fresh set of eyes looking at it before it has to go out, you're going to be able to do that from a viewpoint of the constructor and reduce changes in RFIs.
Which ultimately leads to claims because mistakes, it used to be that we could defend our A&Es because they were just thrown into the lawsuit. Now what we're finding is our firms are actually making mistakes, which is why you have insurance. But if you could avoid it, a simple example, I had a client that does a lot of work with this developer, and something changed in the middle of the project where the tubs were showers. They totally missed it. And now they've done 3 projects with that developer and had 3 claims. So it could have been avoided had they had a checklist, or maybe you said you looking at it again, but in this firm's case, they decided to have a separate set of eyes look at everything before that went out, because if they didn't do the design, then they would be objective looking at the design to say, wait, I don't understand this, or did this change? So that might be another idea.
It's a great place for the person that, if it's not going to be the designer doing the CA, the person that is going to be doing the CA, it's a great place for him, having understanding of how the design was prepared, to look at it with that fresh set of eyes in the interim. So you finish it, give it to that person to look at, and then you look at it.
Him or her.
Him or her, sorry.
I was going to say it and I thought, okay, I won't.
I'm a middle-aged guy. I apologize.
It's all right.
So we move on to site visits. Site visits, this is one of the areas where contractual response owners, your clients will attempt to modify your obligations on site visits. So you should understand your site visits are taking place to help ensure that that design that you prepared gets implemented. But the client needs to understand that they're not paying you to be out there every minute of every day. And even if one person is out there every minute of every day, they can't see every minute of every piece of construction that goes up. So the site visit is to become generally familiar with the progress and quality of the work completed, to determine in general if the work that you observe is being performed in a manner indicating that the work, when it's fully completed, will be in accordance with the contract documents. So those two areas, those two paragraphs or sentences are where the owners like to change stuff. They like to take out the word generally, so that you're visiting to become familiar with the progress and quality. They may add to ensure that the schedule is being complete, the work is being completed on time. And then they go on to determine, they take out the in general, if the work observed is being performed in a manner that will be in accordance with the contract documents, or that is in accordance with the contract documents. And so at this point, they're taking out the when fully completed. And so you're looking at this to guard, to endeavor to guard the owner is another, phrase that's used in the contracts. And they'll take that endeavor out to guard the owner. So they heighten your duties, and, potentially try to make you more responsible for the contractor's efforts. Now, you should observe the project and perform your site visits with an eye towards ensuring that the design will be, when complete, will be in accordance with the contract documents. So during the site visits, you need to keep the owner, your client, reasonably informed about the progress and quality of the portion of the work completed, and promptly report to the owner any known deviations from the contract documents, known deviations from the most recent construction schedule, and defects and deficiencies observed in the work. Again, those are all items that you should be focused on to achieve the design excellence that you're trying to accomplish. Any comments on site visits?
Nope.
You also have the authority, and this goes with the site visits, the authority to reject work that does not conform to the contract documents. So you have the authority to require inspection or testing of work in accordance with the provisions of the contract documents, whether or not the work is fabricated, installed, or completed. Again, that authority is in part to achieve design excellence, in part to achieve the owner's goals. It's for protecting and promoting the health, safety, and welfare of the public, but it's also for achieving the client's objectives. Now, decisions to reject work may impact the schedule and budget. So while you have the authority to reject that work, you should discuss whether or not how that authority impacts society. So is this work that doesn't conform to the contract documents something that impacts the general welfare of people? Or is it something that impacts merely the project? Is the owner willing to accept the non-conforming work as opposed to a schedule or budgetary impact? Be careful of revisions to the contract here, where a lot of time I've seen a lot lately, the have the authority is stricken, have the authority to require, and it's the phrase is then the architect shall require inspection and testing where the architect assumes or thinks that the design is defective or inspection or testing is needed. It puts a more stringent requirement upon you. So what do you do to document the site visit? Paula, you are good at advising your clients how to document what they do on the site visit. So I'm going to turn this over to you. And if Nicole Mangino is on yet, I would like Nicole to chime in.
Yeah, I don't see her. The first thing I can tell you is that there should be consistency in the firm on the style and the format of what you're recording. I've been in firms where they have different people doing their own thing. Somebody records the weather, somebody else doesn't. The tone needs to be professional. I wouldn't use this as a place to document, how you feel about a certain contractor or anything, because anything you put in writing could be on some poster board in a court. So keep that in mind. I always tell my clients this: why not ask your client what they want to get from you and how frequently and to who it should go to? So the reports, some of my firms are using the field reports and giving the copy of them to their owner so they can kind of see what's going on that way. Not sure you need to do that, but I do think pictures are a huge advantage, especially with today's technology. You can do so much on these little iPhones today. But the 300 rule means don't just take a ton of pictures and stick them in a file. You either gonna take, in my opinion, it should be something close up of something that you're really trying to hone in on, or far away if you're just trying to see the general progress of the construction. I've seen claims, and I'm sure Mike has too, where the pictures in the file actually hurt our firm because they captured something and never realized it. So they need to be purged. I also think it's a good training tool. So when you come back to the office, folks that are not doing construction observation, maybe early on in their career, it's a good way to show them what you did and what you did about whatever particular situation that you've captured on film. So I think it's a good way to use for mentoring. And then I think there should be some protocol of, where you're keeping these in a file. I have firms that are using their phones for, contacting the designer and saying, here's what I'm seeing on the site. Sometimes we'll FaceTime them, so you could use these tools, but make sure you're capturing information that may be relevant later. For example, you're making a decision, especially during COVID, we had, folks that weren't going anywhere. So if they had somebody taking photos, then what are you doing about that when you get back to the office?
One of the things about photos, if you're documenting to show a non-conformance with the design and using that photo, you should label that photo somehow so you know at least what area of the building it is, or some other identifying fact as to where it's taken. Not necessarily what it shows what it shows. But where it's taken is important. I can't tell you how many times you get into files and you get photos and you're like, where was this taken? And you get, I don't know, I don't remember. It just looks like piping, so whatever. So if you have the area of the building, that's always helpful for protecting yourself later and making sure that these non-conformities are addressed. Submittals. This is one of the areas where it's an important part of making sure that your design will be achieved by the contractor. And so the contracts require the architects to review and approve or take other appropriate action on submittals for the limited purpose of checking for conformance with the information that you provide in the contract documents and the design concept expressed in the contract documents. This is where the contractors, the constructors, will show you how they intend to achieve the design that you've prepared. And so the submittal review should be taken with an eye toward understanding whether the constructor understands the information that you provide and the design concept expressed. This is also one of the areas where owners are attempting to modify the provisions to make this more of your role in verifying that the contractor has measured everything correctly, verifying the contractor's means and methods. And that's not what this process is for, though you need to understand how the contractor will go about building it, the means and methods, so that you can design a project appropriately up front. This process is for the constructor to show that they understand that concept. Any comments there? All right, project completion. When we get to project completion, the contract states that the architect shall conduct inspections to determine the date or dates of substantial completion and final completion. This is one of the 2 inspections that are done by an architect on the project. It's after the work's substantially complete. So it's not really inspection of the work as it goes in, obviously. It's inspection to determine whether or not the constructor has generally conformed with the design intent of the project. Those inspections should be conducted with the owner to check conformance of the work with the requirements of the contract documents, verify the accuracy and completeness of the list submitted by the contractor of work to be completed. So the contractor should be doing their own inspection and providing you that we needed to, we should have done this better, we need to fix the A, B, C, D, E. You're going out to verify and add to that process. Then you issue this certificate of substantial completion, and you look for, completing prepare the punch list, complete the punch list as part of this project completion closeout process to ensure that the design that you prepared has been achieved, so that you achieve the design excellence you're looking for. You have to collect the warranties. That's important. If an owner has a problem with some of the project, it's important that they have the warranties to get those items fixed within the warranty period. And then the issuance of the final certificate of payment, which is a representation by you, the architect, to the owner and the contractor, that to the best of your knowledge, information, and belief, the work complies with the requirements of the contract documents. That will come after the inspection for final completion. This is an important process to make sure that the design, the construction did achieve what was designed. So project claims. You're probably all wondering, what do project claims have to do with design excellence? And I would say, first and foremost, claims happen even on the best design projects. Claims during the project may impact the budget and the schedule. Claims may impact the health, safety, and welfare concerns of the project, which is what the architect would be focused on more so than the owner and the constructors. And claims, project claims by contractors may impact the manner of harmonizing the owner's objectives with societal objectives. So, Paula, how do you believe that understanding the types of claims that could happen is important to design excellence up front?
Because if you look at stats, and insurance is all about stats, we can predict with pretty good certainty what kinds of projects are going to have claims. For example, many of you that know me know that I say condominiums, you should run away, not walk from those projects. Somebody has to design them though, right? So knowing that they are the highest risk, and when I'm talking about highest risk, it's on a scale of for every dollar in premium the insurance company brings in, on most other projects, it's around $2 or $3 to pay out. For every dollar in premium they got, they're paying out $2 or $3, depending on the service. For condos, it's closer to 18. So it's so off the chart. If you're going to do condos, then there should be some kind of guideline that you follow. And that's a whole nother program, so I won't get there. But when we know that structural engineers have a small fee, but very large liability, just like a geotech, small fee, large liability, because if they have a claim, it's going to be a severe claim, right? So knowing those kinds of stats, I think help a firm knowing, like, for example, schools are higher risk, normally because of the owners and not having enough money to get what they want. So certain project types, I think if you know that, then you can go in with an understanding what the risks are. And I'm happy to help any of you if you want to learn more about a specific project type, what we see and how you can get around it. But it's going to start with, do I take on the project? Do I have a good owner? Do I have a good contract, or if I have an owner who's shoving this contract down me and won't negotiate? You know you're going to have a problem sometime on a project, and if they're not willing to negotiate during the contract stage, you're not going to have a better result in a claim or in a problem phase. So knowing some of those things, I think, help you, because you will have claims. That's just why I'm here. So you are, wait, what are you doing here?
I skipped ahead some slides.
Okay.
Uh,
Yeah,
we
nice.
are at 2:50 and I want to leave some time for questions.
Okay.
So this is a slide that AXA XL has provided this data that relative to the construction phase services, which an earlier slide showed is somewhere between 15 and 20% of the claims against architects.
Right.
64% of those 15 to 20% of claims are inappropriate construction observation.
That's huge.
Which is very big.
So,
Which
so
also, go ahead, Paula.
I was just going to say, what it means is we have a lot of not the right people doing it in some cases. So they're inexperienced, so they don't really know how to handle it. They're not documenting correctly. So we need defense. We need to hire somebody like Mike. He needs some way of getting you out of the situation. And if you don't have good documentation, that puts him behind an 8-ball right from the beginning. So it's inappropriate, or you were contracted not to do it. You went through the exercise of getting the wonderful contract language that I mentioned earlier, where they're going to defend and indemnify you, and you still go out to the site. No, don't go. You're not contracted to go. Don't go. Go ahead, Mike.
Those are good points. Live up to your contract. Make your client live up to the contract.
Right.
So let's see. How to achieve design excellence. And I think this chart pretty much shows what we've been trying to convey here. First, understand your purpose as an architect, why the state issues architectural license for you to practice. Second, understand the client's objectives. Ask the right questions, listen carefully to the answers. Understand that your client's objectives and societal objectives may clash, and that your role as a professional, as an architect licensed in the Commonwealth, is to harmonize what your client wants and what society needs. Understand the construction phase, understand the potential questions and problems that a constructor may have when you're designing. Understand how to schedule may be impacted by your design decisions. Understand how to budget may be impacted by design decisions. Understand your contractual obligations. Understand how and when to exercise contractual obligations. That should be obligations, not authorities, and authorities. understand when to exercise your contractual authority to reject work, um, communicate with the owner and the contractors in that regard, understand how to minimize and avoid claims and questions, and then design the project. So the design of the project comes after understanding all of this other stuff. Any other comments from Paula or Ann, and any questions?
No, I think you summarize it good. Can you speak briefly about the risks of delegated design?
Yeah, so I could do that very briefly. I mean, there are certain things, and I think delegated design should come where there are specialty systems. And where there are specialty systems, the design is delegated to experts. You think sprinkler systems within buildings, fire suppression systems, think roofing systems, think wall systems. And you know, are you putting together the design details? And this is really where the issues come, the interplay between the design and the delegated design is who does it appear is providing the design details. So I've had cases where, you know, the details are on architectural sheet A 4.6, whatever the number is, for a certain element of the work. And you say to the architect, well, how'd you come up with these details? They say, well, I got it from the manufacturer of the system. Well, are they your details or are they their details? And then how are you going to prove that? And so you need to be careful how you detail when you're delegating the design. I hope that answers the question, responds to the question. There is a purpose for it, but it should be used with systems.
Yes, and one other thing to add is the person designing, often I'll hear, well, I'm not stamping anything, so I'm not liable. It doesn't matter. I mean, it's easier to find you with a stamp. But the key too is you need, the contractual relationship is going to require insurance. So if the contractor is hiring the design, quote, delegating the design for, say, curtain wall or something, that contractor should have contractor's professional coverage because he's hiring a designer. And that designer that's doing the curtain wall needs to have professional liability insurance. It's easy to get today. It never was before. So that's the only other thing I would add about that.
Get time for a question?
Sure. Tom,
So-
how are you?
Good, thanks. Yeah, this is Tom Donahue. So I am seeing more and more projects where the architect is not involved in construction observation, particularly with developers who do many, many projects and feel that they've developed their own expertise and they don't need to pay somebody extra. Obviously, that works because it's being done. And I take from the conversation that I've heard here that, you guys presenting don't think that's a good idea, but, you can do it. Paula, you said, if you haven't been hired to do it, don't do it. But, are there any thoughts on how that goes against the laws regarding the practice of architecture? Don't we have some obligation?
Yes, you do. That's why I said you contractually need to protect yourself. If they're not going to listen, you offer to do it, you won't let me do it. So now look at it this way. You're designing, and I'm all about, if I have the risk, I'll take the risk. But you do the design, you're handing it off to somebody else. You lost total control of that risk, but you still have the risk. So you have to, if you're not going to do it, I think the contract is where you can protect yourself. And you also should know that professional liability insurers debit you if you're not doing construction observation. When you answer the question on the application,
Yeah.
you say, how often do you do design? How often do you do the observation? The higher that percentage is, you get a debit because they know you're gonna have a claim. And developers are notorious, you're right.
So Tom, I would say that the licensure law doesn't require the architect to be involved during the construction phase. However, you need to understand that in achieving design excellence, the construction phase is a very important part of that process. And that's sort of today's presentation. So where a developer, the developer's interest might not have society at root. They may have profit, budget, schedule at the heart of their concerns, and not the, is this good for time?
Yeah. I mean, I would not take a job as a designer that didn't include the field observation. I mean, I just feel that strongly about it. But I'm surprised at how much of it I see.
Thank you for your comment.
Yeah. So,
I think we have a couple other questions.
yeah, that's what I was going to say. I think exactly where I was going. I've got another kind of hot topic question, but let's see who else has got things to ask.
Okay, another question. Any thoughts about progress meeting notes, writing or reviewing them, what to watch out for, and any liabilities, i.e. project schedule that's slipping, etc.? Mike, you want to answer that one?
Yeah, so I mean, you have control over writing the project meeting minutes, and you know, from a you want to be honest about what's going on and what's said, but you have the ability to document in a way that is favorable or unfavorable to you as the architect and to your client. And so I think when you're writing and reviewing the meeting minutes, you want to make sure things are fairly stated and use that opportunity to fully vet out the issue if you need to fully vet it out to support your activities and whatnot. So, I mean, that's sort of my advice is you have control of it, be honest, but also understand that the words matter if you get to a litigation setting.
I look at it the same way as documenting your field notes. You know, you want to be professional, honest, consistent, and make sure that it goes to everybody it's supposed to go to. And that's where I say, and I think Ann mentioned when you first set up the meetings at the beginning of the project is the time to ask the question, how often, how and who needs to get information so that you are responding to what the client wants. Don't assume they want everything like all your other clients, because you might be surprised to find out they want more frequent or less frequent. Just ask. We got a lot of age differences too, and some people like email, other people like live meetings. So I think you need to ask the question. My personal opinion.
And any comments on that? I mean, we're out of time, so I think Kira's going to be kicking us off here any minute.
I think if any of you have any follow-up, Anne, if you have anything to add.
No, that I agree.
But thanks everybody for attending. It was quite a participation. So thanks.
Yes, thank you, everybody. Appreciate it very much.
And thank you to our speakers.
You're welcome. If anybody needs any information, just let somebody at AIA or myself know, or Mike or Ann.
I always learn something from you guys.
Okay.
That is the
All right,
goal.
everybody. Have a good
All
day.
right.
Thanks.
Take
Bye.
care.
Take care.